Hi folks, it's Mike Loscialpo, your favorite outside lawyer here with another edition. This past weekend I went skiing for the first time this season. Been skiing for 50 years, as many of you already know, and that's my favorite sport. By the way, the snow was great. There was excellent coverage in the mountains of New England. As I was on the chairlift, it dawned upon me that I need to put out more videos about how do-it-yourself estate planning services could actually hurt your family more than it helps. And I'm going to share with you a case study. This video series on can a do-it-yourself estate plan hurt you is broken up into 3 segments. The following is part 1. So I'm going to tell you the story about a client that I did a consultation with recently. They used a do-it-yourself estate plan service that charged them $400 to $500 for a all-inclusive package with a revocable living trust. And it offered attorney assistance. So they would book a 30-minute call with an attorney from this plan's network to look over the documents that were self-generated through this service. They use a question and answer process and it spits out documents. And so that the attorney can give them feedback before they sign it. So this couple was married, they had adult children, and their goal was for that if one of them dies first, the surviving spouse would get 100% of the assets. If upon the last person to die, their adult children would then inherit their assets in equal shares. How hard could that be, right? That's what most people probably want. So they opted for the living trust package. It includes a pour-over will. Now, the pour-over will is a backup mechanism. Obviously, if you have a revocable living trust, you could see other videos that I made about this. You're supposed to fund it with all or most of your assets so that no assets fall into your estate and you shouldn't have to probate a will. But the pour-over will is a backup mechanism in case something falls into your estate because you didn't fund it into the trust. And it's supposed to say just pour everything into the trust. It's not supposed to say this person gets this and that person gets that because that's what's said in the trust. In the revocable living trust, they stated that all assets owned by the revocable living trust, including their real estate property, their primary residence, goes to the surviving spouse, and upon the last to die, each of the 4 children get 25% each. No problem. However, in the revocable living trust, they added a special directives clause, which really was unconventional and is not typically done by an attorney this way. It said that only 2 of their 4 adult children get 50% each of the real estate property that they reside in. Now, of course, it's contradicted by the actual residual primary remainder clause. Okay, in the trust. So they're saying at first, all of our assets go to our kids, equal shares, 4 of them, and then all of a sudden it's taking that away in the special directives clause. I saw that and I pointed it out to the client. They didn't realize this was a conflict. They proceeded to state that the special directives clause was put in there because their reasoning was if they only give the residence to the 2 adult children, they also have provided beneficiary designations on their retirement accounts, and they kind of took what the value of everything is today, and if the other 2 children inherit the retirement account and these 2 children inherit the home, they should be about even and fair and equal. However, also in the will, it actually says, again, all 4 children equally get my real estate property, but it conflicts with the special directives clause. So this thing is all over the place. If you can see, the problem here is if both of them die and their children, who are now the trustees, have to go and administer this, it's going to be a little bit awkward, would you say? Those 2 children who were supposed to get half of the house each, they're going to probably want to get half the house, but the other 2 children are going to say, but wait a second, in 2 other places it says we're all supposed to get a share of the house. So that can create a problem that's even worse than actually not having a plan. So they weren't quite at retirement age. They'll live a normal life expectancy. they'll probably need to withdraw their assets from their retirement account to live for the next 15 to 20 years before they pass away. So what if that IRA account is now depleted or mostly depleted? Is it going to be a fair and accurate and equal arrangement if only two of the children become the new owners of the house when they pass? No. So all around, as you could see, this could be a real nightmare. And this was not something the clients even thought about because they didn't have an attorney to help them with this process. They just answered questions in a questionnaire, and the service just spit out a document. There was another problem, which had to do with their self-created plan. The wife died prematurely, and this is, sad, right? But this happens. The husband requested a consultation with me to discuss any trust administration requirements. It was a bit awkward because I had to explain all these challenges and these problems almost to the point where he didn't want to believe that I was telling him the truth, because what happened was, unfortunately, he took advantage of that 30-minute consultation with an attorney. And the attorney looked at all the documents during the 30-minute consultation and said, yeah, this looks about right. Go ahead and sign it. But if he had died as the surviving spouse, okay, and there were no spouses left, his estate would have been a complete mess, of course. They would have had to go through litigation, most likely, because the children would not have agreed upon who's supposed to get what. That can cost the estate tens of thousands of dollars. Way more than it would have cost to go to an attorney to get a plan to begin with, right? The other issue is, and I realized that because I actually do consultations for one of these services, okay? I do those 30-minute consultations. Why? Not because they pay me well. It's because I want to help people not make these mistakes. I'll tell you the secret. These attorneys get paid about $40 or even less per consultation, 30-minute consultation. That's a small fraction of what they get paid for normal attorney's fees, which would be about $200 per 30-minute. So do you think that they took the time 30 minutes before the consultation to fully read through all the documents? Nope, they didn't. And if they did, they would have caught all of this stuff. And because these clients have already decided to pay $400 to this self-help company, do you think the attorney thinks that they're going to retain their firm and pay thousands for an estate plan? No. So the attorney really doesn't have much of a vested interest in this. So who loses here? The problem is the attorney is not getting paid well enough, so they're not going to pay a lot of attention. The client doesn't have attorney help to actually represent them and spend hours interviewing them to make sure everything is right so that we can avoid these problems. But the client will die and the estate will be administered. And because the client has already died, it's not their problem because they've already died. It's their loved one's problem. The choices we make today in trying to cut corners, whether we want to spend $3,000, $4,000, $5,000 to have a competent attorney create our plan from scratch, involving multiple interviews and hours upon hours of evaluation and consultation. Do we want that versus paying $400 or $500 and do it ourselves? Well, you see here, there's a problem if you're not going to have a competent attorney actually looking out for your best interest, although they give you a 30-minute attorney-assisted estate plan, which you saw how in this example how that went. Who loses the most? Your children, your friend, who really has nothing to do with your estate, but you appointed them as a guardian to your children or a executor or trustee of your trust. They're an innocent third party that now has to deal with litigation because there are beneficiaries that one's claiming one thing and the other is claiming the other because you tried to save money on your estate plan. All right. At the end of the day, it's going to cost them more money than if you just paid the attorney to begin with to do it. Now, I don't want this to sound like a commercial for retaining attorneys because I am an attorney. like I said, I actually still am one of the network attorneys for one of these services. And unlike the other attorneys that just breeze through the documents within that 30 minutes, I actually look at the documents ahead of time. I explain all the problems and all the unforeseen things that they didn't think about. At least I know they have something that's not going to be worse for them than not having a plan, right? It's not going to be what they totally need because there are still a lot of missing things, but at least I didn't let something slip through the cracks and cause this family harm by not explaining something, right? Should they come to me? Absolutely. They should come to me and get a whole plan that's comprehensive and customized for them as opposed to a self-directed one. But at least I can sleep on that. So this was an introduction to an actual case study. I hope you enjoyed it. Stay tuned for part 2. Make sure you watch that video because there's more.